Someone's trying to reach Mr. Ross now. Okay, aggressively too.
Okay.
I wonder why.
What you want? I know what you want, but what you want right now?
I know what they want too.
What
Anyway,
you want right now? Anyway.
let me get back on the bench. Hey y'all, I'm Ebony K. Williams here, host and attorney extraordinaire. Welcome to Holding Court, where we analyze the very latest in legal headlines, the ones that got all the streets talking. You know what we do? We dig deep into how the courts impact the culture. We break it down, going straight from gavel to your news feed. And every week, we keep it 100. Right, Dustin Ross?
That's right.
Dustin Ross, honey, I'm
Yes,
so glad
yes,
to see you
yes.
back in studio. You like our new space?
I love our new space. All things new. It's a season of newness
like that.
in our new season of Holding Court.
New season, literally. We got new greenery.
All that.
You're giving green vibes.
Thank you very much. It's everything new.
Everything is new.
Mm-hmm.
Some might call it new.
New. We ain't talking about the movie, okay?
I love it. All right, we're going to get into this docket today. Everybody was texting, paging, DMing. I said paging. That's funny.
Mm-hmm. We old school. That's all right. They knew what it meant.
There was a time and place.
Okay, I would love one today.
Listen,
It just gives you another barrier, right?
Yeah. And also, I can get back to you when I'm ready. Anyway, everybody was reaching out. And I'm sure they were reaching out to you too and tagging you, Dustin. Harvey Weinstein. Ciao.
Who in the hell left the gate open?
Oh, literally overturned rape conviction. Now, don't worry, ladies, gentlemen, children. He is still incarcerated as we speak. He's in Rikers right now, matter of fact. And then that same court said, but don't get any ideas, Negro, because R.Kelly, your ass is still where you at, and your sentence for child pornography has been upheld. So we'll talk about why different scenarios there, right? A lot of people, Dustin, are suspicious that there's a race component. And we're going to address that too, because we have to, because this is Holding Court.
Yes.
And then last but not least, I really wanted to talk about this one. It didn't just happen, but it happened recently. GloRilla got a DUI. Right?
Yeah. I saw that.
It's
shocker. Not funny, but I saw it.
A mess. And that part is not particularly breaking or exciting, but what I do want to discuss is the fact that she did something that not a lot of people do or know is even an option, and then they also don't know the consequences of that option, which is she refused the breathalyzer. So I want to talk broadly, Dustin, about what happens when and if one decides to refuse the breathalyzer test as it relates to DUI. So we're going to get into it. All right, we're going to start with Harvey Weinstein. This really was breaking news and shocking.
Shocked the shit out of me.
Shocking because I think for most of us, we figured the Harvey Weinstein, because it was such an enormous deal when it happened. It took forever and a day, it felt like, for many of us that were covering that case in real time, Dustin, for it to be adjudicated.
Yeah.
And there were a few different cases. So let's be clear, right? Okay, so finally you're adjudicated because he's got LA stuff, he's got New York stuff, he's in jail, he's getting older and, more decrepit by the day. And really, it was the definition of, what's it, throw away the lock and key?
Yeah,
that kind of thing.
That's what they
lock
did
him
to
up
him,
and throw away the key. And who was thinking about Harvey Weinstein?
I know I wasn't.
At all. I thought the next time we would hear about him would be his, very much like OJ. Hear about his death and a bunch of fake outcry and fake mourning and let's move on. But surprise, surprise. Harvey Weinstein's 2020 conviction has been overturned. And this specifically, y'all, was a rape conviction. It was a turn at the appellate level 4-3, meaning of the 7 judges, 4 voted in favor of the overturning. 3, though, this is important too, said not so much. But of course, they were literally outnumbered here, Dustin. When you saw it, what was your first thought?
I was surprised that it even took place because I didn't know that it was possible. I thought the charges on him were final and, we were done with that. I didn't know there was an opportunity there for him to have a conviction overturned. Right. He's the poster child at this point for these sort of crimes. Yeah.
Slovenly looking.
Horrible.
Just makes your skin crawl. I mean, just between, it's really, I agree with you. Like, his legacy is the face of Me Too. His legacy, his whole legacy. I don't give a damn what movies we're talking about and all this and that and the impact on Hollywood and all the red carpets and all that. His whole dying legacy, Dustin, will be
the Me Too.
The poster boy, like you said, the face of the reckoning of rape and sexual assault in this industry. And yet here we are with an overturned conviction. So a lot of people felt like you felt, Dustin, right? Like, I didn't know this was possible. And see, this is why, you hear lawyers talking about on appeal. And a lot of times it's almost like during my beauty pageant days when like, they crown the winner and it's like, and then if the first runner up is also an important role. And if something were to happen to the winner, you would be tasked with, and everybody be like, yeah, whatever, bullshit, until that actually happens. I could deviate and tell a first runner up story, but I'm going to choose not to right now.
Thank you, because I can't take it.
You can't take it. I know.
I cannot take it.
Tip you some water. Some water. Okay.
My nerves.
No, listen.
There's too much going on in the world today for these random.
Actually, that part, bumps and bruises.
Noises, you know what I'm saying?
We don't need no bumps and bruises in here. Okay, so back to, a lot of people thought, think appeal shamil, right? Like whatever. Until that appeal happens and there's a different outcome.
And it's fruitful.
Yeah. So don't miss out on the significance of an appellate court. Sometimes, not often, but sometimes they'll pull a fast one. And I don't say that disparagingly, because that's why we have appellate courts. But that's why also we have normally superior courts that sit atop the appellate division. So this is not over. But let's get into the why that we even got to this point. The court says this. The majority opinion, I should say, said this, because don't forget, 3 people said we're not rocking with it. But the 4 majority said, we conclude that the trial court erroneously admitted testimony of uncharged, alleged prior sexual acts against persons other than the complainants of the underlying crimes, because that testimony served no material, non-propensity purposes. Okay, that's a big one. It's a mouthful. It served no material, non-propensity purpose. The court compounded that the error when it ruled the defendant. Okay, so it compounded that error when it ruled that the defendant, who had no criminal history, could be cross-examined about those allegations, as well as numerous allegations of misconduct that portrayed defendant in a highly prejudicial light. So all of that word sandwich to say what? To say that the lower court messed up by allowing both testimony and then, here's the important part, the cross-examination. So not only did you allow testimony that we feel was irrelevant, that's immaterial, you also then cross-examine Harvey Weinstein about that irrelevant testimony. We feel it was irrelevant. And then all of that caused prejudice, meaning the perception of this defendant to be so kind of sullied that we feel it was overly prejudicial without enough probative value.
That's bullshit.
Well, damn.
Don't they have to build the case, right? Again, picture painting, right?
Yeah.
So adding in these accounts of him being a sexual deviant in some way, or these allegations, that's the whole point, to create the idea that he would do this
to paint the picture. No, absolutely. So let's back it up. Okay, let's go to law school. Let's go to second year of law school in most law schools across the country. Law School 101, we all take a course called evidence, Dustin. And in evidence, you learn what pieces of potential evidence, and let's go, what is evidence? That could be testimony from individuals. That could be photographs, videos. It could be all of those things. But often the evidence comes in the form of testimony in a trial. And one of the things that a judge has to evaluate, not only a judge, not a jury, just a judge, is this evidence that I'm about to allow into this trial, which will paint the picture, as Dustin Ross just told us. That's the whole point of trial, is to paint a picture for the jury. If you are the prosecution, you are trying to paint a picture of the defendant that is likely sullied and dark and unconscionable and thus deserving of punishment.
Right.
If you are the defendant, though, you're trying to paint a picture of your client as
an angel,
relatively harmless and not deserving of
the
adjudication or punishment. Correct. So the judge's job is to say, what evidence do I allow in that's going to paint a picture one way or another that is fair and reasonable and not so prejudicial, so it's not going to make the defendant look so bad as to dissuade the jury in a way that's not directly connected to this case. So I'll give you an example. Let's say I'm on trial for theft. I'm on trial for stealing that sweet little bag right there, that sweet little Birkin bag. And the judge has to say, well, and we're going to make you the judge.
Okay.
Because that's fun. Look, he didn't stand up straight. Look, not the hand gavel. Can't stand you. Okay, Your Honor, I want to present into evidence that is proving to prove the guilt of Miss Williams, that she stole that Birkin bag. And I want to call to the witness stand senior producer Ashley Hobbs. And you're going to say, okay, what is Miss Hobbs going to testify to? Well, Your Honor, she's going to testify to the fact that Miss Williams previously stole a piece from my store. That would be admitted testimony. Why? Because it is testimony that would go to prove the propensity, you heard that word in the statement, it would show the propensity of Ebony K. Williams to steal things. And what is this trial about?
Ebony K. Williams stealing something.
Now, what would be more challenging is that, let's say we were going to bring to the witness stand, and you saying, well, what is Mr. going to testify to? Well, Your Honor, I want to call Mr. to the stand because I want him to testify to the fact that Ebony said she was going to go out on a date with my homeboy and she never showed up. So I'm going to say she's a liar. Right. So I'm trying to get this in under the guise of I'm showing that she's a liar and can't be trusted. You see how far away that is from what we're actually accusing me of? So that's just like a light, funny example
of what they're doing
here.
Yeah.
That's the breakdown.
I get it.
That's the breakdown. So they're saying that the trial court let too many people testify against certain things that might not have been directly correlated to their satisfaction, Dustin, on the specific guilt of this rape. Because we got to remember, what are we in court for on this case? Rape. Now, here's the good news. That's still not the end of the road. That's not he's innocent all of a sudden of this rape in 2020. That's not justice. That's not how this goes. It means the prosecutors will have to start over. And that this will be set for trial again. And Harvey Weinstein and his legal defense will have to pony up and get ready, get back on it, because they will have this same trial all over again from the beginning. And this time, the prosecutor, so now it's a retrial of the same case and the same facts, which I would argue almost is always worse for the prosecutor. Why? Because now the defense knows your hand.
Yeah.
They know your whole playbook.
Yeah.
And the appellate court then already slapped you on your hand to say you did too much the last time, so you can't go there again. And so now the defense has more advantage. That's the way that's going to play out.
All right. Well, that makes it make a lot more sense than just reading that he had a rape conviction overturned, right?
And now it's like we getting jiggy with it in Rikers. No. And keep in mind, again, he is still being held because he has convictions that are still standing. And that's why he's still in Rikers as we speak.
That's where his nasty ass needs to stay.
Needs to be. Very interesting. I'm going to cite some of these other. Doug Rigdor, who I'm fairly certain, I believe, was one of Cassie's lawyers as well. He certainly represented a lot of folks from the Roger Ailes claims and O'Reilly claims. Anyways, highly, highly, highly respected attorney in these spaces. He has represented 8 of the Harvey Weinstein accusers as well. He slammed the decision. He said this. He was with you, Dustin. He said, courts routinely admit evidence of other uncharged acts, where they assist juries in understanding issues, painting the picture, as Dustin Ross will call it, modus operandi or scheme of the defendant, he said in a statement. This is literally what you said, right? He's like, okay, yeah, but maybe it wasn't totally correlated, but they helped paint that picture of this is how this individual is. That's MO, right? This is how they roll. This is how they move. This is what they do. And that should be valid.
Absolutely.
So again, it's going to be a retrial.
Well, here we go, I guess. I mean, of course, if you're facing charges, you're going to do with whatever you have to do to absolve yourself of that. We should expect that from him and his team. And
don't forget, we saw this with Cosby, right? Where his conviction of one of those women was overturned. And it was overturned
about that.
Yeah. I mean, because a lot of lawyers were in my box like, what in the Cosby is this? With the Weinstein overturn. Yeah. A broken clock right on, right twice a day. One of Cosby's convictions was overturned. Why? Not because the court thought he didn't do what he was convicted of doing. That's not why they overturned it, Dustin. This one was a real tough pill for many of us to swallow. They overturned it, and I have to say for us to swallow, because I had a hard time when I read the headline that Cosby's conviction was overturned, because it was not on the merit of the case. But then from a kind of legal fairness lens, it was the right call. Why? Because Cosby's admission, don't forget, we have Cosby on record himself in a videotape deposition saying, yes, I gave those women, I'm about to say Percocet. Not Percocet.
No, it was, what is it? Oh, it's on the tip of my tongue.
Well, what was
Quaaludes. Yes.
Shout out to Ashley Hobbs again.
Super producer.
Super producer from behind the door.
That's right.
Fuck IVF. Quaaludes. So we have Cosby on the record, Dustin, out of his own mouth saying, I absolutely gave those women Quaaludes, which of course impairs their ability to give consent to the forcible sexual acts that then took place. So it's like, okay, this is open and shut, right? No, because Bill Cosby gave that deposition, Dustin, after the then prosecutor gave him immunity, which that's what immunity is. Immunity. So immunity says, oh, Mr. Cosby, feel free to go ahead and tell us everything that happened. We're promising we're not going to prosecute you. And then they did what? A new prosecutor came in office and went ahead and prosecuted his ass, and he was convicted on that basis. So the appellate court had to say, why do you do this to us? We believe that the case was proven on the merits, but a deal is a deal is a deal is a deal. Mm-hmm. And that previous prosecutor made a promise to Mr. Cosby and his team that particular evidence, that deposition, would not be used against him. And then y'all went around and used it against him. So we have to overturn it. So here we are.
Wow.
Here we are. So y'all stand by on Harvey Weinstein. It's not done.
Yeah.
We'll stand by. You know, we're going to cover it here on Holding Court.
Absolutely.
Okay, moving on to somebody who is not getting a reprieve in the court of law anytime soon. His name is Robert. His name is Kelly. Robert Kelly. For anybody, because you know it was that commentary in the comments too. Okay, well, we freeing Weinstein,
free R.Kelly, yeah. Until it's your daughter or your niece.
That part, I mean, yo,
is the music that good? What Nene say? Music ain't that good.
That's what Nene said. But I got a sorority sister. I ain't gonna name her name. Who said she said sign her up. She said if R. Kelly come to Madison Square Garden tomorrow, she's going.
Well, here's my thing. Well, never mind. That's a show for another time.
No. I said it. You say it.
Here's my thing. Canceling R. Kelly was never about us not enjoying the music that he made, right? It was about us not supporting him financially. So to me, if you go on YouTube and find a random account, you know what I mean, that is posting that music, you can enjoy it without putting streaming dollars back into his pocket, or you know what I mean?
Look at him being smart.
You can still play it at your house. You know what I'm saying?
If you got it on vinyl. Around. Right, you got the vinyl.
You can play it at your house. If you got the vinyl, you know you can do that. But you just don't want to.
You're not adding to the defense fund. No, that's true, right? Because anything that is putting new revenue is literally going to advance someone who we now know to be a convicted sex offender.
Yeah, full stop for me.
Full stop. And again, convicted much like Weinstein in several different jurisdictions. Pick one.
Yeah.
Okay. So R. Kelly, let's talk about this one. 7th Circuit Court of Appeals has upheld his conviction. So this is a 20-year prison sentence on child pornography and the enticement of minors. So this is the Chicago. I remember, because when we first launched Holding Court, a lot of these cases were still active. So it was like a Chicago case. I want to say there was even like a Minnesota case or something random in the Midwest. And then there was Atlanta, and I want to say New York. He had a lot of cases in a lot of different places. So this is the Chicago one. So that has now been upheld by the appellate court here. He had already been sentenced to 30 years. Yep, this is the New York one. So this is the RICO. This is the one, Dustin, where people are drawing, right or wrong, I think it's premature, comparisons to what Puff is dealing with, the Diddy of it all. Where New York State has enacted the same type of, these are like the Giuliani laws, okay, who really made famous these RICO, where it's not really just about the selling of drugs or the prostitution, if you will, whatever, or it's not about that. It's about the conspiracy.
Yeah, the network
of all the different individuals who played a part of this. And that tends to be a much stronger case when you bring those RICO style cases. And that is what happened with R. Kelly in New York. That's why he's serving 30 years of racketeering, sex trafficking in the state of New York. So both the 20-year sentence is ongoing and the 30-year here in New York is ongoing. The ruling reads in part, in its words, the nature of Kelly's offense is horrible, horrific. We will not second guess that exercise of discretion. So this is the appellate court saying we're not we're not going to Monday morning quarterback what the trial court has decided. We're going to let that stand. No statute of limitation saves him, and the resulting sentence was procedurally proper, and especially under these appalling circumstances, substantively fair. So they're saying the very opposite, right, of what we saw the court in Weinstein say. Weinstein's appellate court says prosecution did too much. We're going to, recall that. It was not relevant, and thus we think the verdict was unfair. It's a lot. We broke down why, but, R.Kelly appellate court saying just the opposite. It is what it is.
Forget about it.
Forget about it. Whatever the trial court did, we like it.
Well, I'm going to stick beside them.
Right. I'm not going to question nothing they did.
That's it.
And that's what it is.
Get comfortable.
Right. The key is still thrown away.
Okay.
And you're still locked up.
Step side to side, but not out. Okay.
Not funny. I can't.
That's what they said. Damn. Well, don't mess around with kids.
Well, listen,
then you don't have to worry about this kind of stuff.
You don't have to worry about this type of stuff. And as for the suspicion or speculation that this is another case, we've got to always look out for that good hotep argument. This is another case of America-ing with KKK, all capital, where the white man gets the break and the brother stays in jail.
I'm not getting ready to have a pissing contest over which rapist is the best.
Woo!
So they can both deal with what they have to deal with. I don't feel, by virtue of my blackness, I don't feel implored to defend R.Kelly.
You mean to tell me, Dustin Ross, you don't want to use the beauty of your melanin and your black currency as a black man in America to put those chips on the table in protection of Robert?
No, I don't.
Shocker. Okay.
No.
Yeah, I mean, it's the same thing I said on one of my griot sidebars, right? Like, no one is saying, I mean, at least, let me be clear, I'm not saying that white men should get away with things that black men don't get away with. But I'm also absolutely not about to sit up here and say that that is a legitimate defense
at all
of black men or black people in America, that white folks get to do it, so should we.
Not in this damn case.
And also, I think that argument is so anti-black.
Very much so.
And if you can't piece that together, I challenge you to do so.
And I implore you to get a copy of Bet on Black, the good news about being black in America
today.
On today.
That's it. On today. It's a nice supplement to your holding court listening.
Yeah, they need to read that, because anybody who would make such a silly a silly take.
But we hear it. I know. And it's
Come on.
I guess for those of us that choose to think highly of black men, it's particularly egregious.
Yeah.
When I hear that argument. I'm gonna leave that part right there. Moving on to the DUI of it all. For those who have never.
Not the DEI.
Okay. Listen, I like how you segue right there. DEI. DUI. Come on, somebody. All right. So if you have never gotten a DUI, God bless you. It's a really horrible experience. First of all, it's horrible if you actually did it and have to, live with those consequences. It's also just really bad. Like, even if you're innocent, DUI isn't just, it's very involved. It's one of the more involved
for a
legal
long
processes.
time.
Yes. Yeah. And some of y'all are like, huh? If you know on this one.
Through hell.
It's a lot just trying to get it dismissed or deferred, or that's what I'm saying. So when I zoom out now, Auntie E said it. No, what I'm saying is, regardless of the did it or didn't do it of it all, DUI is just a lot. It's a very expensive process from a legal standpoint. And one of the reasons it's a lot, and this is going to connect to the case we're talking about here with GloRilla in a minute, is because every defense lawyer cannot handle a DUI. And I'm telling you that as a defense lawyer. That is its own specialized practice. And if you sitting out here and you're listening to this episode and you or somebody you love or care about is having to deal with a DUI on any level, and they just got arrested, they're down there in lockup right now, they got one on appeal, do yourself a favor. If you have any resources, do not just go to a general mom and pop shop criminal defense lawyer to handle your DUI. You need somebody that does DUIs. Golly, I can't emphasize that enough, because people don't know that, Dustin. That is the other, you go to some lawyers' websites and they'll say, I'm a criminal defense lawyer. I do everything from drugs to this to that. You need somebody to do DUI. Somebody that lives and breathes and got a mattress in a DUI court. I'm serious. I'm serious. You see, I'm passionate about this because I know.
Yeah.
You know what I mean? And those lawyers charge more for that reason. That's the point I'm making. That's why it's so expensive. But if you find yourself in peril in this way, and you got 2 pennies to rub together, you better rub them motherfuckers and get you the right lawyer.
It's very intimidating having that in front of you.
Oh yeah.
And when you don't, when you get your deal or whatever, and they tell you, well, we're not gonna put that on your record, but you have to do this shit. It literally adds up, and your entire year is gone.
Man, listen. And there are a lot of lawyers that have DUIs on our records. You know, God, it's really the grace of God that I don't have one, in the sense that I'm not going to sit up here and act as if I have never I'm just not going to do that. I just was covered. Favor was on me that day.
And thank God for that.
And thank God for the favor, because it ain't fair. But what I'm telling you is, I know a lot of my law school classmates or people that were in law schools in different places, because shout out to BALSA, the Black Law Students Association. You know, we all have some level of community at various law schools in the country through that organization. Anyways, one of the things, you passed your classes, you got your grades, everybody's ready to graduate from law school, you've submitted to sit for your bar exam, right? Which is the required, like, you can't practice nowhere for nobody if you do not successfully pass somebody's bar exam, right? But part of that bar exam is something that we call the character and fitness component. So before you take the test to see if you know the law, states get to decide if we're going to let you even sit for the test. Based on, and this sometimes has a lot of anti-blackness and all types of little isms that show up, if we say you have the proper character and fitness to even. So I've seen Black law school graduates be denied bar opportunities because of back child support. I've seen them be denied because of back rent. I'm telling you what I know. I've seen them certainly be denied for DUI convictions. And then I've also seen others be permitted. So this is the point of this, y'all. It's a heavy consequence when you're talking about DUI.
Right.
It ain't no little shit. It's not a suspended license. It's not that that's little, but this is not that. Now let's get to GloRilla. Okay, so she recently was arrested for a suspicion of DUI. What a name. Gloria Hallelujah Woods.
Gloria.
I've
only heard it once in my life.
Gloria Hallelujah.
Hallelujah Woods. Yep.
All right. So she was arrested at 6:00 in the morning. You're so silly. April 16th in Gwinnett County. Shout out to Atlanta. Her arrest affidavit states that she was stopped. This is important. Stopped after making a U-turn at a red light. I say this is important. Why? One of the first things you have to prove with any traffic situation, and DUI falls under that in this way, you have to prove that the stop itself was legitimate. Because if you're a defense lawyer, and again, this is why you spend your last on a good DUI lawyer. No, but for real. Because that's going to be one of the few places, y'all, that they can help you, is they can challenge the stop. Was the stop legitimate? In this case, if this affidavit is to be true, she don't have a good challenge to the stop, because it's alleging, at least, that she made a U-turn at a red light. So that would suggest some level of impairment. But let's say it was something a little more subjective, like
a rolling
stop. I was going to say weaving between the lines. Those types of things are not as egregious for a stop, and then the right judge on the right day might say not strong enough grounds to stop. Case dismissed. Whew. And then it really is gonna be Gloria Hallelujah.
What?
Anyway,
I'll change my name. Okay. Shit.
Listen. Right. Okay.
Anyways,
those were not her facts. She was stopped for making a U-turn at a red light, so that's going to be a pretty egregious allegation for a stop. The officer then said that she stopped in the middle of the road once the cop hit their blue lights. Again, kind of further aggravating the claim that she was intoxicated or inebriated, because she's just moving in ways, stopping in the middle of the road just because the blue lights are flashing. Like, you're not operating in a way that a reasonable, sober person would, is the claim here. All right, so let's go forward. Officer says that he told her to pull over and noticed that her eyes were watery and bloodshot. That's some boilerplate DUI stop language, you know. Let me guess what's going to be next. Odor of alcohol. Let me look at the facts. Oh! I swear. No, I just did it in real time. I promise you. Officers said they smelled marijuana coming from her black Mercedes, and they could do what? Smell alcohol from her breath. It's almost like we've been here before, right?
Yeah.
I swear to y'all, I know y'all like, Gabby, come on. Now, I swear to God, I just did that in real time. Okay, because it's boilerplate, because that is the language on 99.99.99.99% of all DUI police reports. Okay. GloRilla admitted to having consumed alcohol earlier in the evening. Okay, we'll get to that. The report states that though she refused to disclose how many beverages, because that's what's going to happen. They're going to pull you up and say, have you been drinking? You're going to say yes or no. You say yes. How many drinks have you had? You're going to say, know that every time you open your mouth to say any of that, you are doing what? Providing evidence against yourself and your interest on a DUI accusation. All right, but here she goes. She doesn't say how many, and insisted that she was good enough to drive. That's what she stated. Okay. Another officer pulled up to assist. That's interesting. I don't like that, by the way. If this really is a stated one person by herself, 6 o'clock in the morning, so we're assuming daylight, why you need two officers? Why you need, or at least if there's two officers, they should be in one car. Why do we need backup?
GloRilla is this big.
Right.
Okay.
I don't like it.
And according to the video footage we saw, she was not being combative with those officers at all, like in any way.
I don't like it. The additional officer searched the car and found marijuana along with an open alcoholic bottle, according to the report. Officer noticed that her sentences were not always making sense and that she had a hard time finishing her thoughts.
She always talks like that.
I was going to say, I mean, I know a lot of people that have trouble finishing their sentences and ain't had a drink. But anyway. At which point, another cop arrived to assist in conducting field sobriety test evaluations. So the field sobriety tests were done. We know what that is. That's walking the line. That's holding your nose out, doing all this, physical coordinated tests. The breathalyzer was offered. She refused it. So this is what I want to talk about. When, Auntie E, should you take the breathalyzer? When shouldn't you take the breathalyzer? The answer is it depends. It depends. It depends on a few things. One of the things it depends on, Dustin, is what jurisdiction you live in. So like on all episodes of Holding Court, y'all, number one, what we do on this show is meant to serve y'all. It's meant to serve the culture. It is not intended to substitute actual legal advice. Take your ass to a lawyer where you live if you find yourself or your loved ones in any of these predicaments.
That's on you, baby.
I would say that's on you and that's on God. Like for real. No, for real. Now, that said, we're going to speak generally here for a second. Okay. Depending on where you live, you might not even be able to refuse a breathalyzer. Okay. Or depending on where you live, you might, you want to refuse the breathalyzer. You want to know your rights.
They take you to the hospital. Take your
motherfucking ass right down either to the hospital or the precinct and draw that blood.
Yeah.
Because that statutorily comes from a place that says we will not allow the refusal of evidence needed to properly ensure your conviction once it gets to the trial level of a DUI case. Okay. And I remember I'm old enough / young / old enough to remember when those mandated blood tests came down. And that's relatively new. That's in the last 20 years. That used to not be a thing. But in the last 20 years, these legislators said, we tired of these really, really good DUI lawyers playing in our face and getting these cases tossed. Fuck out of here. We gonna get that. We're gonna get that evidence come hell or high water.
So is that a federal thing? Is that state?
That's state.
Okay.
That's state by state by state. And some of those states, it's a really, really brilliant question, Dustin. Some states have repealed it on constitutional basis that says that no one should be required or forced to give evidence against their own conviction. So, from a legal nerdy standpoint, all this stuff is like fascinating and really dynamic.
Yeah.
You know what I mean? But that's why I say check with your local listings. Okay.
Yeah. Check your local listings. For real. For real.
Listen, I'm really serious on this one, y'all. Check your local listings, check your local statutes, check your local jurisdiction. Some of y'all can refuse and fight it out. Some of y'all can refuse but still be forced to give blood. Some of y'all just, out here. So, under the scenario of you live in a jurisdiction where you can refuse and not be forced to give blood, let me play out what your options could look like. Or somebody blue, maybe right below or right, because I've also seen that. I have definitely had on my case file, especially when I was a public defender, people charged with DUI that blew 0.07, which is technically statutorily below. Because most states everywhere, it's 0.08, right? But I've had cases where it's 0.07 and you're like, how did this happen? Because the officer just wants to insist upon, well, they might have blown right below, but the field sobriety was awful or that this was awful. And so they still want to say that we have enough other evidence to prove intoxication.
I don't like that.
Yeah. I was really very good in the courtroom. So most of those, of course, I got dismissed.
Okay.
I even got some .08s dismissed. And then some others, we just had to go to trial.
That was before our time.
Before our time. But thank God, guess what it is now? Our time.
Okay. That's right.
So let's take an example. Somebody that blew right borderline, right either on it or right above it. Here's what I would say are the consequences of refusing to blow. So typically when you refuse to blow, know that there are going to be consequences and repercussions. I would argue that they are so punitive that they are unconstitutional, but I'm not on the Supreme Court yet. So, yet. You saw how I said that.
Justice Williams.
Now, come on now. Don't make these little brown cheeks turn pink now. Okay.
What?
So right now as it stands, most jurisdictions would say that, again, the consequences of refusing a blow are severe, and they are. So some of the consequences, y'all, for refusing to blow could be, number one, they're going to immediately that night suspend your license for up to a year. And unlike, let's say, and a suspended license is a real problem for a lot of people. That means you might not be able to go to work. That means you might not be able to pick your children up from childcare, so that can interfere with your custody agreement. There's just severe consequences to literally not having any access to a lawful right to drive. And that's what happens when you refuse to blow. Whether you end up getting dismissed, that case, whether you end up being found not guilty at trial, that year suspension of your license stands. And that's, I think, probably the most deterring consequence of refusing to blow. Versus if you do blow and you get dismissed at court, like in your case where you may just blown like a .09 or something like that. So maybe either you get found not guilty at trial, or get found dismissed. In those cases, if you blew, your license suspenditure goes away. For obvious reasons. Even if you were convicted, let's say you were convicted, heaven forbid, you still can apply for what we call a limited driving permit in most jurisdictions that will let you at least drive to and from work or even make accommodations. I've seen judges accommodate for child custody, so you can still have limited driving privileges. But if you refuse flat out, you do not qualify for any limited driving privileges. Can you believe that? But that's how serious, that's how much they want that evidence of you blowing on that breathalyzer. So that's one place where some would say reasonably, Dustin, if you have barely been drinking and you feel like and this is hard because now we're playing, this is craps now, right?
Yeah.
But you don't really know what that blow gonna look like or none of that. But basically, if it's borderline or that type of situation,
just take it.
Think about taking it, or at least consider the severity of the consequences of not. Which, like I said, the most severe one is no exception, no limitation, no driving for a year, and that's a heavy consequence. Now let's reverse it. Let's say you've been drinking your ass off, and you already know
that you about to blow
that
a 13.
You about to, listen, 13, 18. I've seen people blow a 24. No, I'm serious. That's not good. Yeah. So what that is now you're in what we call aggravated DUI range. That's not all DUIs are also not created equal. Okay. So if you in an aggravated range, that could be up to an aggressive misdemeanor. It could be a felony DUI. I've seen that. You don't want to blow. Under no circumstance, period. Why? Because again, what could be just a conviction of a regular DUI because of refusal to blow now becomes an aggravated DUI, now becomes an even worse situation for you. And why would you want to give them evidence of things being worse than they thought? See what I'm saying? So if you drunk, you drunk, you probably want to consider carrying the consequences of not blowing, because the consequence of blowing is going to even be more severe.
Damning, yeah.
So listen, again, y'all, check your local listings on this DUI shit. I don't purport to be giving individual recommendations around this. This is too serious. This is too specific. Down to the county where you are charged with can vary, but the takeaways here are this. Know that many of you have an option as to whether to blow or not. Get legal advice on whether to blow or not before you try to Russian roulette this shit on your own. And if you find yourself or someone you love charged with a DUI, get an actual DUI lawyer. Please, 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 please do not get a generalist. This ain't that. This ain't just a tooth cleaning, bitch. You need you need an endodontist, an orthodontist, an oral surgeon.
All the way.
All the things. Okay, capiche?
All the way. Cover your big
Capiche?
cover.
Capiche?
And stream GloRilla's new mixtape. Everything.
Oh, is it good?
It's good.
It's good. Dustin say it's good. Well, I think we did a day's work on that one.
We did.
Y'all join us next time. Next week, we'll be right back in session. In the meantime, y'all stay glowed up and Gloria Hallelujah, because that's a name for your ass.
Woods.
Woods at the end. No comment. Keep the faith and always what you want the people to do, Dustin.
Read your terms and your conditions.
That's right.
Please.
Amen. Holding Court is produced by Uppity Productions. Host and executive producers here, Ebony K. Williams, yours truly, and the Dustin Ross. Executive producer in Dossie, McCraw. We've also got our senior producer, Miss Ashley Hobbs. Creative consultant, Jay Kleinberg. And please, if you love the show, follow us on Holding Court and listen to us on Apple Podcasts, Spotify, and any and everywhere you get your podcast.
That's right.